Johan, we're sitting with everyone that wants to be reasonable but still protect their rights. So maybe you can just outline a little bit of a framework of what is the legal protection of a landlord's rights and a tenant's rights, and how does that work in the South African law?
Well, Amoré, I think in the last couple of years, we've seen a tendency to the protection of the consumer. We have maybe in a certain way overprotected the consumer, to be totally honest. But we've got a multitude of legislation that regulates the relationship, for example, between tenants and lessors. To start with, the Rental Housing Act 50 of 1999 is a rigid and a robust piece of legislation that in no uncertain terms stipulates the obligations of the lessor and the obligations and rights of the tenants. The regulations of that piece of legislation was equally issued shortly thereafter, and that basically describes the undesirable rental practices that occur. So in no uncertain terms, you can use that as a guideline to determine whether your actions are detrimental to the rental sphere or the rental background. But it's very important that we have a look at alternative legislation that was introduced as well, whether it applies to the relevant piece or not. Consumer Protection Act, for example, that was introduced in 2008, where you have a supplier and consumer, so not even or necessarily a lessor or lessee, but even protecting the consumer buying a toaster at Pick n Pay, for example. The shopping entities being the suppliers and then the consumer being Joe Soap, who purchases the article itself, and enjoying extensive protection measures to say that when you sell me something, you basically warrant that it is free of defects for a period of 6 months. If it's not, I can bring it back. You either have to repair or replace it. So we really have an extensive legal framework. And then we've got statutory bodies, obviously, in place that enforce those specific rights. We've got the Consumer Tribunal, which is instituted or basically created on the guidelines of the CPA or the Consumer Protection Act. And then all the listeners probably know about the Rental Tribunal or the Rental Housing Tribunal, which is an alternative dispute resolution mechanism in terms of which they resolve rental disputes that might arise between lessors and lessees. And that rental tribunal has equal powers to impose orders that are equal to that of a court at the end of the day. So not only do we have those strict regulations and pieces of legislation in place, we've got the statutory bodies to enforce those, which is approachable by the general public itself.
And I want to just add with what you said is people do not understand what the rental tribunal is, and it feels like this body that you have no idea of what their functions are at all. I would encourage you to go and Google them and see what are they about, and look on their website and see how you can start a process, because this body's CSOS, Rental Tribunal, CCMA, and the CPA, all of those bodies, we call them bodies, but it's actually like I want to say like a mini court, for lack of better words, because they were put in place because the courts are so jam-packed with other court cases that you might never have the chance to dispute your smaller case than when someone has millions of rands to dispute a case. And these bodies were established to reduce the load on the courts. And these bodies, we call them bodies, but I want to emphasize that they have the same power as a court. So if there's a court decision, they emphasize it, they stamp it, it's like a court decision. So make sure you've got your ducks in a row. If you have a dispute with your tenant or with your landlord, make sure you've got your ducks in a row and that everything is in writing, and that you follow the due diligence steps of the rental tribunal. And they will help you in a much shorter time than what a court will do, and their decision is as final as a court.
That's definitely so. And you've just touched base on one of the statutory pieces of legislation that we did not mention, and that being the Community Schemes Onboard Service Act, or CSOS for short. For those who don't know, those who are involved in community schemes, such as body corporates in the event of sectional title schemes, or homeowners associations, such as full title properties or estates, that specific body is available if you have disputes with regards to your ownership, if you have disputes with regards to the body corporates or the rules and regulations of the homeowners associations. It can be tested by CSOS. We found in practice that these organizations are highly effective, contrary to belief. We thought at a certain stage that it might be a statutory body that is created and it's going to be clumsy, but it is not. It is definitely there to try alternative dispute resolution, like you said. The courts are highly congested at the moment, and we always see that this person or that person is issuing summons against the other or bringing an application, and that clogs the system. Yes, so therefore, the more alternative dispute resolution mechanisms you have, such as tribunals or such as the Ombud itself, that is just obviously there to enforce your rights and obligations.
And if you want to know more about the CSOS, Johan and I have done an extensive video about the CSOS, so maybe just click on the link here and have a look at that CSOS. But yes, all of these bodies are very important and will help you a lot easier than to appoint someone to represent you. These bodies were made for the public. So approach them, it's not as difficult, and they will assist you in a very approachable way, or they'll help you.
Definitely.
Good. Thank you, Johan. We really appreciate all your legal advice. And as always, thank you. Have a good day.